Hey guys, today we're going to go through the motion to recuse, which Attorney Cruz filed on the 16th of January before the trial was going to start on the 21st. So here it says that you have to file it within not later than 10 days prior to the hearing or trial. And he has put here that good cause is shown. That's weird. Because they didn't learn of the alleged grounds for recusal until the 15th of January. So it starts out by saying that on the 15th, the prosecutors went for a motions hearing, and obviously the defendant. And during said hearing, Lisa Lott failed to follow the applicable law and continued her pattern of violating Georgia's Code of Judicial Conduct Rule 1.1. Judges shall respect and comply with law, promoting public confidence in the judiciary. So Mr. Cruz is saying that during the hearing, the court instructed Mr. Faust through counsel that he was not to file any legal briefs following rulings by the trial court. Undersigned counsel cannot follow said directive, as same would violate Professional Rule of Conduct 1.3, which provides a lawyer shall act with reasonable diligence and promptness in representing a client. Reasonable diligence, as used in this rule, means that a lawyer shall not, without just cause to the detriment of the client, in effect willfully abandon or willfully disregard a legal matter entrusted to the lawyer. So he's saying that the instruction was unlawful and improper because it would obstruct Mr. Faust's building of the appellate record and deprive him of his constitutional right to effective assistance of counsel. So Lott was basically like, you're not allowed to file anything else just because. She's like, I've had enough of your shit and your logic. And then the other thing that happened on the 15th is that the court refused to reconsider its order denying Mr. Faust's amended motion to suppress evidence obtained due to illegal searches and seizures, which is his motion to suppress evidence, despite the state conceding that the law was unfavourable to the state's position during a prior hearing. In regard to the motion, on November 13, 2025, the following exchange occurred in regard to said motion. So Chris with a K, Mr. Bolden, with what I'm trying to explain, there's a motion to suppress that Mr. Cruz filed on October 2nd. The court, okay. Mr. Bolden, the second part of the motion to suppress is they then used that cell phone information to have a Georgia State trooper pull Mr. Faust over for the purposes of obtaining a surreptitious DNA sample. The court, okay. Mr. Bolden, the state is going to concede that the controlling case law on the stop by the trooper is adverse to the state's position. And that's bolded and underlined. The court says, okay. And then Mr. Bolden says, so that part of the motion to suppress, we're not contesting. We're conceding that anything related to Trooper Wooten's traffic stop should be excluded. And then Mr. Cruz follows that up with, will a written order granting the motion to suppress come out, or how would the Honourable Court deal with that now that how would we respond to the motion during the status? And the court says, let me look at the motion first before I answer that question. But of course, anything that the state either concedes or stipulates to, vice versa, will certainly put in writing. But I need to take a look at what the motion says. The court not only refused to reconsider its decision, but the court also refused to provide Mr. Faust with a hearing on any ground alleged in the motion. Despite advisement that the motion was conceded by the state, shockingly, the court refused to consider its ruling. to reconsider its ruling. Counsel for Mr. Faust earnestly believed that the court had mistakenly denied the motion. However, once the court made clear its position, Mr. Faust's counsel realised that the court intentionally decided the motion in favour of the state, despite the state conceding the issue. Such a blatant disregard of the law in favour of injustice was terrifying for Mr. Faust, as undersigned counsel had expressed that it was a mistake. However, the court's actions made clear that it does not care about the fairness of Mr. Faust's trial, nor whether he is innocent, but solely on obtaining a conviction. Mic drop. And then it just goes on to say that this action supports the court disqualifying herself pursuant to Rule 2.11 of the Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. And an impartial judge does not deny a substantive defence motion regarding the admissibility of evidence when the state concedes that, based on the law, it cannot in good faith contest said motion. So, in light of the court's action, undersigned counsel realised that the court's actions towards Mr. Faust had not simply been a misunderstanding of the law or unfavourable rulings, but a deliberate attempt to ensure a conviction is secured in disregard of the law and Mr. Faust's constitutional rights. To provide a history of the court's pattern of conduct to undermine the fairness of Mr. Faust's trial, in addition to what occurred on the 15th of January, the following has occurred. So this is about the Larry Peterson hair analysis. So on 2nd of October, Mr. Faust filed a motion to exclude Harry K. Peterson and any other microscopic hair analysis expert testimony because it's junk science. And instead of granting Mr. Faust a hearing or ruling on the merits of the motion after the state advised that it would not call Mr. Peterson, the court initially denied the motion because the Honourable State stated that it would not call Mr. Peterson, then orally stated that it would suppress the evidence because the Honourable State advised that they would not call the witness, but then told undersigned counsel that in the event the state changed its mind, then at that time, undersigned counsel could make a motion. An impartial judge does not set a motions hearing deadline, then refuse to rule on a defence motion filed before said deadline, because it may be detrimental to the state or because the state may change its mind. The court has had no regard for Mr. Faust's position of knowing what evidence would come in or be excluded at trial. The court's ruling focused on protecting the state's ability to do what it would like during the trial at the expense of Mr. Faust's rights and trial preparation. Number 2, on November 13, 2025, the court held hearing for admission of other S acts. This was for the purpose of the state to obtain permission to admit this person's allegation as such, and undersigned counsel spoke with that person and they admitted that they don't recall a single incident of any S violence. And then Mr. Faust lawfully served that person a subpoena to appear at the hearing, and at the start of the hearing that person was nowhere to be found. And she was going to say that the statements she made were due to being led by police into making said statements. And apparently there's some cognitive issue there which impacts memory and makes that person more suggestible. So there's just problems in that. Yeah, the court denied that request in favour of admitting the state's evidence at the expense of Mr. Faust's rights. Whoopsie. Okay, so during that November 13 motions hearing, The court told Mr. Forst's counsel that a lawfully made speaking objection was not a thing, depriving Mr. Forst of the use of a lawfully made objection. So Mr. Cruz says, speaking objection, Your Honour. Objection, speaking objection. The court, I'm sorry, what? Mr. Cruz, speaking objection. I'm objecting to a speaking objection. The court, tell me what you mean by that. Mr. Cruz, sure. So, speaking objection. A proper objection is objection, relevance, objection, hearsay, objection, lack of foundation. This is a speaking objection. This is an objection where you're making argument. I object to a speaking objection. The court, okay. Mr. Cruz, I'm just going to tell you right now that that's not a thing. I'm going to overrule that objection. Mr. Cruz, understood. Wow, that was a tongue twister. And then on that same date, during that hearing, while Mr. Forst was examining the state's witness, Sergeant Black, on the credibility of the claims made, the state made a relevance objection. To preserve the adversarial and testing nature of cross-examination, Mr. Forst was asked to either explain the relevance of his questions outside the presence of the testifying witness or continue with questioning as the relevance would become clear. And in short, witness credibility was the relevance. However, the court required Mr. Forst to proffer the detailed purpose of his cross-examination in the presence of the witness before allowing Mr. Forst to continue his line of questioning. So I don't know how valid that was. And then Mr. Cruz wanted to proffer excluded cross-examination questions onto the record for appellate review. And this is what happened. The court, I'm going to sustain the objection. Mr. Cruz, yes, ma'am, the court's indulgence. All right, so for the purposes of the record, that concludes my examination. But just so proffer the questions that would have been asked, I would have asked the detective after. And then the court interrupts. I'm sorry, what are you doing now, Mr. Cruz? Just proffering for the record the questions that would have been asked. And the court says, I'm not going to allow you to do that. Again, November 13th, the court ignored clear legal precedent that if a party is seeking to proffer evidence in an other acts hearing and the opposing party objects, said evidence must be presented by means of traditional evidence. Mr. Forst provided the Honourable Court with case law and our written objection to any proffer motion regarding the law pertaining to evidentiary proffers in other acts hearings. In a consistent manner, the court denied the motion contrary to the law. The state did not seek to take advantage of the trial court's disregard of the law in their favour and honourably and ethically introduced the testimony as lawfully required through testimony. So, tick for the state, but still. And the next point is about a pattern of conduct around communications. So this is all to do with emails and basically whenever Cruz would send things, it would just get ignored. So that's what's in the exhibits. If we go down here, there's copies of the emails. And it says here, based upon the court's pattern of conduct, the court is disinterested in Mr. Forst, does not hold in regards any of his rights, and is placing its hands on the scales of justice to secure a conviction. regardless of Mr. Faust's guilt or innocence. An impartial judge does not ignore that law, instruct a defendant's counsel not to file briefs on said defendant's behalf to protect appellate rights, undermines counsel's lawful objections, refuse to enforce subpoenas, deny motions in contravention of the law in favour of the state, despite the state ethically and honourably advising that the law is unfavourable, and ignore defendant counsel's communications regarding scheduling matters, but promptly respond to the state. So she responds to the state, like even on a Saturday, but just ignores Cruz. So the only reasonable explanation for all of that is because the state just wants to ensure a conviction. So Cruz is saying that he believes in good faith that the court is just trying to get a conviction. And then he goes on to say that we all want justice for Ms. Baker, but not at the expense of dishonouring her memory with a false conviction. And if this matter continues to be presided over in a manner that puts the interest of or favouritism for the prosecution and law enforcement over the interest of finding out the truth for the Baker family and a defendant's right to a fair trial, a conviction is guaranteed regardless of the evidence. So they want to recuse her. And then this is verification and written oath in support of motion to disqualify or recuse. So that's just a summary of all of the other things, all of the things he just talked about. And the undersigned swears that the information given is true and correct. Signs that, and that's the motion to recuse, which was denied. So, but I mean, it was denied by another judge that they brought in to look at it. And from what I've seen, it doesn't just seem to be Lott that is a bit dodgy. I think it's all of the judges in that area. And I think, yeah, they were just against Attorney Cruz from the beginning. So I don't think he had much of a chance. But he tried, and that's all he can do, really.